Hey everyone, welcome to the Darshan Talks podcast. I'm your host, Darshan Kulkarni. It's my mission to help you trust the people and the products you depend on. I'm an attorney, I'm a pharmacist, and I advise companies with FDA-regulated products. So if you think about drugs, wonder about devices, or obsess over pharmacy, this is the podcast. This is a live stream for you. I do have to emphasize that I am an attorney. My guest is an attorney, but neither one of us are your attorney. I am a pharmacist, but I'm not your pharmacist. So this is neither legal advice nor clinical advice. These are considerations, but they don't necessarily reflect the opinions of the host, the guest, our employers, or our clients. If you like what you hear, please leave a comment, please subscribe, please share. You can always ask our guests questions. And you can always reach out to me if you like on Twitter at Darshan Talks, or just go to our website at darshantalks.com. Today's interview is really going to be fun. My guest is the Frank Stanton Professor of First Amendment Law at Harvard Law School. She specializes in copyright, trademark, and advertising law. She also has a casebook with Eric Goldman called The Law of Advertising and Marketing, which they have actually kept reasonably priced so that people who are interested in advertising law can use it as a reference work. So ladies and gentlemen, our guest for today is Rebecca Tushnet. How are you, Rebecca?
Great. How are you?
We're doing well. Thank you again for coming on. So let's start with the basics, just because I'm curious now. How did you get into writing this advertising law textbook? What sort of drove you for that?
Well, so I was interested in intellectual property law in law school, and I was fortunate to when I was done clerking, I worked for a law firm that had a lot of intellectual property cases, and I discovered there that the federal law that governs trademarks also actually has a whole other half of governing false advertising. And I fell in love with the topic, but realized that it's not actually taught very much in law schools. We teach securities law, right? We teach lots of different subfields of law, but we don't often teach advertising law as its own separate thing, even though everybody advertises. Nonprofits advertise, politicians advertise. So advertising is so pervasive. And so we wanted to create a resource that would enable teachers to more easily introduce this as a course. And it's also just a great capstone course because an advertising lawyer has to know a little bit about everything, not just intellectual property law, not just false advertising law, but you have to at least know when you need to ask further questions, because advertising is inherently going to involve questions about what your product does. And so the great thing about advertising law for a lawyer is you have to learn a little bit, at least maybe a lot, about the business that they're in to really understand their advertising. And so it's just, I think it's a great topic for kind of a working lawyer.
Which I think is really interesting, because I think about the fact that I do a fair bit of advertising law, but I do it in the context of obviously food and drugs. And one of the things in my world is this idea of labeling and advertising, and right, how they are similar, but in the FDA's opinion, those are technically completely different issues. And have you ever interacted with the interplay between both of those, or has that not been something that you've sort of done?
Yeah. So right. So in the bigger world of advertising, right, stuff on the label is just advertising, right? That's and it's not going to be regulated any differently. Although there can be a little bit of difference in class actions, in part because of the restrictions that courts have increasingly put on class actions these days. Only stuff on the label basically is going to allow for a class action. If you put it in one ad and not in other ads, then that's going to prevent any class treatment of a challenge to that claim. But yeah, so I have always thought of the FDA rules as being based on, a very specific statute that has no particular basis in kind of the theory of advertising or other things, but, might be justified for, complex regulatory reasons. And also to the extent that you're dealing with, prescription drugs, that's also just a different situation than most things that are advertised to their ultimate consumers.
So you talk about how there's almost, for lack of a better term, a disparate treatment under how the FDA treats it versus, as you said, the SEC versus everything else. For example, the FTC, I assume, is is primarily where that gets played out.
And private litigation, right? So so consumers and competitors, which is where I focus. Yeah.
Oh, interesting. So I guess my first question for you is, as we start looking at the FDA's disparate treatment, one of the things, and we very briefly spoke about this before we went online, we started talking a little bit about this idea that the FDA is trying to understand how they can deal with their version of advertising law and how to reconcile that with what the rest of advertising is doing. And as someone who's knee deep or neck deep in advertising law, could you talk a little bit about how strong is the FDA's footing around the types of controls they want to have around advertising?
Right. So this is an extremely complicated question because the larger movement in First Amendment treatment of commercial speech has been to be ever more rigorous in saying you can't do anything unless the commercial speech is false or misleading. So and we have this really big divide. So unlike political speech, false or misleading commercial speech can simply be banned. But court decisions have been creating this increasing, really cliff, right? So it used to be that false or misleading speech, commercial speech, could just be banned. Other kinds of commercial speech could be regulated under a much lesser standard than that applied to non-commercial speech, like New York Times reporting or political speech. And the Supreme Court has really cut back on that kind of intermediate category. So now, if your commercial speech is truthful and non-misleading, it's very, very hard to regulate it. Getting to the point where, the Supreme Court has struck down restrictions on where you can put signs, and is right now hearing a case about whether you can ban digital billboards that are for off-premises activity. And it's kind of a bad situation in general. But what's particularly challenging is it's done all that while leaving the possibility of banning false and misleading commercial speech completely. That's still supposedly very easy to do. So the obvious thing that does is it puts a lot of pressure on the distinction between false and misleading commercial speech and commercial speech that is not false or misleading. So historically, the regulators tended to take the position that if you hadn't proved something, then promoting that claim was false or misleading. It's increasingly unlikely that courts are going to accept that, and we've definitely seen that in the FDA cases. And yet, there is still this discomfort, I think. Even courts that have gone very far don't really want to destroy the FDA. But the FDA, right? So the FDA's entire business is regulating speech. What is a drug is entirely defined by how it's advertised, right? If I have a can of paint, right, if I say, this will color your wall white, then that gets a completely different regime than if I look at that. If I point to that same puddle and I say, this will treat your eczema, right? Completely different regime, entirely based on advertising. So. The reason that we're getting weird results in especially cases on off-label marketing is that courts are going right up to the edge of saying, okay, the whole FDA thing is unconstitutional, and they're not really willing to go over it. But the theoretical reason why they won't go over that edge is not present. So. We're in a very weird time, and I think you can see that I think the companies are a little hesitant on this too. So one of the things that I find particularly interesting that we haven't seen is a big push to get the same rules for off-label marketing applied to direct-to-consumer ads as applied to advertising to doctors. So the companies have aggressively and successfully pushed to make marginal claims to doctors, and there's no First Amendment reason that they couldn't make those same claims on TV to individual consumers. And yet, radio silence, right? So why is nobody pushing that? I think because people are nervous about that. And the other thing I think that I wonder about is, suppose we do get this regime in which you can say anything unless the government proves it's false or misleading, right? In that case, do we have all this preemption of, tort claims left? And I think the answer is no, right? That was a trade. That Congress gave pharmaceutical companies a fair amount of regulatory protection for being under heavy regulation. The heavy regulation goes away, there's really no reason the tort liability wouldn't come surging back. And I think that's probably has something to do with the hesitancy to sort of go straight to the consumer.
So I have so many questions that came out of that. The first one I kind of want to delve into is this idea you mentioned, which is the communications with physicians versus the communications with direct to consumer, as you put it. There's an entire job function in the pharma world called medical affairs, and it's very clear. And most pharma companies go out of their way to talk about the fact that this is not promotional. This is educational. So you're doing continuing medical education. You're doing scientific discussion. You're trying to fall under that First Amendment protection associated with scientific discussion and get that First Amendment right protections. And if you don't do that, you might fall under advertising, and that causes all kinds of problems. As you said, that's resulting in some level of disparate treatment. I guess my question for you is, as you start getting into a world where physicians theoretically could have the same types of claims marketed to them as direct-to-consumer ads, would that distinction remain? Is there a reason for two different job functions?
Yeah. So, okay. So there's a practical reason for it, to be sure. I do not think there's a doctrinal reason. And let's be clear. Medical affairs is marketing, right? From any like, why are they paying those people? They're paying those people to sell the drugs, right? And it's true. You have to soft sell. And I should say also, like, when people do it with rigor, right? Ideally you're doing it in a truthful way. So there's certainly nothing wrong with that, but it's marketing, right? And there's good marketing and bad marketing, and hopefully they're staying on the good side. Although obviously we have plenty of examples of people who didn't, and including things that are making national news like opioid marketing.
Absolutely.
But those are marketing jobs, all right? And from the perspective of constitutional law. And there's really the difference is truth or falsity, not like how specific or are you providing the scientific background. So the internal distinctions made by the industry do not necessarily map onto the constitutional categories, nor, and I'm not actually advocating that they should. I'm just saying that in cases where these distinctions are pressed, right, courts have made it easier and easier to say whatever you want to say, provided that it is not shown to be false or misleading. Right. And so one of the key moves here is who is the burden on? Right. And so for a long time, FDA approval seemed to provide the dividing line. Right. So if the FDA has approved the claim, then everybody agrees it's true. If it hasn't, then you can't promote it. But there might be some things that are true, even though the FDA has not yet approved them. Right. Yep. And under current First Amendment doctrine, it's not surprising that courts are saying, OK, well, you can go out and say these things. And there's really no reason you couldn't also say them to consumers, except that internal decisions to hold back, which I find fascinating.
I find the conversation itself fascinating. So let me start by talking about this idea that that pharmaceutical companies are. You hinted at this to me before we got online, but what is the impetus for for a pharmaceutical company? And when I say pharmaceutical companies, I mean any FDA regulated company, but for a pharmaceutical company to not push for the ability to market off-label?
Yeah, so I think I have a couple of thoughts about that, although they are speculative. So one thing that I think about a lot is, why do pharma companies accept the whole apparatus compared to supplements, which are a wild west, and the most minimal of regulation, including I mean, ordinary consumers are incredibly deceived about this. Ordinary consumers tend to believe that supplements get scrutiny for their claims, and that therefore the claims wouldn't be on the market if there wasn't evidence for them, and that's actually the opposite of how it is, and it's quite confusing. So. I think one reason that one might be reluctant to push the boundaries is worry about further blurring the difference between. So pharmaceuticals have this advantage in that they have the weight of several generations of the idea that the FDA is overseeing this, that these are special formulations that have been tested and developed in ways that are just different from supplements. And the supplement people are working hard to chip that away, but at the same time, doctors and pharmacos are working hard to maintain that. And I think if you were seeing prescription drugs advertised in the same way as supplements are, right, and without all the disclaimers, without the heavy language that signals like this is serious business, I think you would have a harder time maintaining that distinction. I also think there are liability reasons. So, one, if pharmaceuticals are nothing special, then they don't deserve the kind of preemption protection they get against a lot of claims. So, maybe you would have to start paying for, the side effects and so on in ways that, for ordinary tort claims, right? The fact that, we expect a certain number of injuries in ordinary operation is not the end of the question of whether you're liable. We actually have a set of tests for whether you're nonetheless liable for, like everybody knew this might happen and then it did. Sometimes you have to pay for that. And we've given pharmaceuticals special treatment, again, for good reason, but it was part of a package deal. And if advertising regulation is no longer constitutional, it's not obvious why we should accept that trade-off anymore. So, I also think there's probably an interesting kind of insurance role. That is, pharmacos have, you really want to be covered by a nation's an insurer's formulary, right? And again, if there's no difference between pharmaceuticals and supplements, why would we be paying, why are we paying all this money for one set of treatments?
Well, I can argue that one. I can argue that one. I would. So I think on that one, I think the difference is that the insurance company wants to pay for effectiveness. So I think most insurance companies, and I've worked on formulary committees before, you don't even look at the advertising. You look at what are the specific claims and is the evidence supporting that claim. So a supplement, if for the most part, and there are some notable exceptions, don't make it onto formulary because you just don't have the evidence. Saccharomyces and the like are the exceptions because you're just looking for gut sort of replenishment. But no, I'm not aware of a single supplement outside that comes onto formulary. But your point overall is still completely valid.
Right. And right. So none of these are absolutes, right? but I do think that the core of FDA approval of claims has contributed at least to the creation of an apparatus where, okay, so we know when to believe claims, right? And of course, there's some off-label things that you accept in part because there are no other treatments, right? Or the thing is rare enough, and it's worth it, especially for cancer, right? So there are cases where you would accept off-label claims, but in general, the fact that people spend billions of dollars generating the relevant evidence is in part, at least, a function of the apparatus where if you get an FDA approved claim, lots of good things start to happen, right? Yes. But that is a judgment about speech, and it's not just a judgment about truth of the speech, and that's what makes it legally vulnerable, despite, I think, even the very free speech libertarian Supreme Court that we have now is probably not willing to take down the FDA in full.
Right. So which raises this other question. We've spoken a lot about engagement with physicians, and we've spoken a little bit about the dichotomy as compared to speech to consumers or to patients. What we haven't talked about is something that's happened recently, which is what happens when government officials promote a product for an off-label use, say a president who talks about again, this is not a political discussion, but more of if he or she truly believes that product works for an off-label use, is that inherently a problem? And are there any limits to First Amendment right speech there? And conversely, should people lose their ability to prescribe because they talk about the off-label use of a product, and because despite some might say lack of evidence associated with it?
Yeah, so I want to separate those two because I think they are very different. Yes. Professional licensure is a separate kind of state involvement. Absolutely. But from the First Amendment perspective, we have a long tradition of evaluating when someone can be held liable for encouraging other people to do dumb stuff, dumb or even illegal stuff, right? And that tradition is profoundly shaped by a history of government punishing people it doesn't like, right? Mm-hmm. So the people that you don't like, their bad advice you're just going to perceive that bad advice as inherently more likely to be acted on than the bad advice of people you do like, right? So the danger is going to seem more imminent. So in response, this is basically the paranoid First Amendment, right? That we're very worried about what the government might do. And so our paranoid First Amendment says you have to be really, really sure that the speech is going to produce imminent harm. So, drink bleach may well cross that line because there's very few circumstances under which that is anything close to okay advice, right? And we actually saw people did it, right? So that might cross the line.
I'm sorry, quick question. Is that the equivalent of shouting fire in a crowded theater?
Right. So the key thing here that is often omitted from that quote is, falsely shouting fire in a crowded theater. The idea is it's persuasive, it's immediately damaging, there's very little chance to correct it. So we punish you for it because we don't think, as we often do, that counter speech will be enough to solve the problem. And the open question is, okay, when it's just generalized advice, is there really imminent harm?
So I'm hearing you, and I'm hearing that there's an argument whether there is imminent harm, but does it change if it's the government saying it versus it doesn't? Okay.
I mean, part of the issue here is who's going to stop the president? It turns out you can't even impeach him for promoting violence and trying to get people killed. And that's just a governance problem, right? But in terms of so bad medical advice in general, we have this weird sort of two-pronged treatment of that, right? So there is malpractice, right? So many things, especially if said by physicians, if a specific person takes that advice, right, that can be malpractice. And for a long time, I think some people have recognized, there's arguably a First Amendment problem with that. But the fact that a specific person relied on the doctor, took their advice and was harmed has generally been thought to be enough to justify holding the doctor liable for malpractice. And then I think similarly, this gets to your question of, can you lose your license, right? If you've demonstrated that you are in the business of providing very dangerous advice, then we probably don't want to sanction your treatment of people, right? You demonstrated that you are not necessarily reliable. Like even if you could, splint a broken finger, it's not worth the risk to have you with a license. Like I guess you could probably go be an EMT, I suppose.
You just don't get paid as much, but yeah.
Yeah.
But one of the things you talked about malpractice, and I think that's a really interesting thing to raise, because I think malpractice in general starts with the concept of did you owe a duty? So does the president owe a duty of somehow giving correct medical advice?
Right. So historically, where you didn't have a professional relationship, the idea of incitement has substituted for that concept of duty, which is like the idea that you were doing it in a situation where there was no time for other people to correct the bad advice, and we worried that other people would get swept up and take the bad advice.
And is it, if it's a national podium where that conversation is being had, and let's ignore the bleach question for a second. Let's talk more ivermectin or talk a little bit about one of those. Does the discussion get into, well, there were multiple steps beyond that. So whether you're talking about
absolutely,
or ivermectin, you have physicians who would be natural, quote unquote, barriers to prescribing something that's not out there. Plus, there's a whole discussion out there saying there were no other treatments at that moment. People were dying, there were no options. And is there a certain role a government official plays to calm the people, even if it's not completely truthful, for lack of a better term?
So, I would never want to endorse that, right?
I'm not endorsing it. I'm just asking.
Right. Yeah. So I don't. Okay. So from my perspective, I think what this is about is that we don't have a very good account of bad speech by the government, right? So we have lots of theories about how to deal with bad speech by private citizens, but very few of how to deal with bad speech by the government, because there's kind of no way for a citizen necessarily to avoid it, right? So in school you can opt out of saying the Pledge of Allegiance, but you generally can't opt out of having it said to you, right? And there are a number of theorists who think that this is just a deficiency in the American understanding of free speech, that it is all negative and really no positive. So some people have posited that you ought to have a right to truthful speech from the government, right? But we don't do very many positive rights.
Fascinating. Rebecca, I can keep going. This is just an incredibly fascinating conversation. But as I mentioned to you, I usually aim for 15, 20 minutes. We're already at 29 minutes. So you are absolutely fascinating. I do have a couple of questions for you before I let you go. Would that be okay?
Absolutely.
First question, which is something we've been flashing the whole time. What's the best way for people to reach you?
Right. So I'm easy to find on Twitter or Tushnet. So that's probably the best way.
Excellent. Next question. Based on our discussion, what's something you'd like to ask the audience?
So I would be very interested in what people in pharma are willing to say about supplements. Although I don't know that I would get the best, the deepest answers in a public forum.
Yeah, I think that's probably fair. I think that's probably fair. Here's another question for you. What's something you've learned in the last month?
So my son is involved in the Civil Air Patrol, and I've learned something about the Observe, Orient, Decide, Act, or OODA loop, which is something used in fighting, apparently developed by a fighter pilot to describe basically how you successfully win like an engagement at the tactical level. Is you try and get inside your opponent's OODA loop, so that you are making your own decisions and responding faster than they are able to respond to you. I really like that concept.
What are the elements in that again?
Observe, orient, decide, act.
Okay. Very cool. That's actually a really cool one to take away. What's something that made you happy in the last week?
My daughter started doing debate, which I used to do when I was younger, and I was really delighted to see her enjoying it. Policy debate.
You're practicing at the highest levels of law, as one might say. So I'm going to ask you this question. In your opinion, do you think that debating is an essential skill of being a lawyer?
So I would say debating is one like way to do it, but any successful lawyer needs to be able to break down an argument into its working parts and analyze those parts. And debate is one good way to learn those skills.
Thank you. Because you get those all the time, which is, I should have been a lawyer because I like arguing. Like, no, that's not the entire basis of it. So last question. What's something most people don't know about you?
I really like collecting and doing wooden jigsaw puzzles.
Really? Well, that's an interesting one. Do you do the metal ones as well, or just the wooden ones?
So I've done like one or two metal ones. I think they're often like tiny, and also actually a lot of the pleasure of a jigsaw puzzle, especially a wooden one, is in the feel of it, and they tend not to have the greatest feel.
Interesting. I've seen I used to watch them on YouTube, the big ones that are like, you need to move this before the other one moves out. So I didn't know there was a whole community around that. So that's really interesting. Well, this was an absolute pleasure, Rebecca. Thank you so much for coming on.
Well, thank you for having me.
I do hope you'll consider coming back again.
Absolutely.
Thank you again.
All right. Thanks.